Good afternoon. My name is Joseph Tucker Edmonds, and I am the Associate Director of the Center for the Study of Religion and American Culture. Welcome to the fourth episode of the second season of the Center's Religion and series, and our final episode for 2021. Religion and is a series of monthly conversations between leading academics and practitioners hosted by the Center to engage and enhance critically important conversations at the intersection of religion and American studies and our broader culture. The third episode that happened in November was a dynamic and thought-provoking discussion on religion and conspiracy that discussed both scholarly and contemporary implications of conspiracy as it relates to religion, the state, and the future of democracy. We're so appreciative of the comments and feedback that we have received from our viewing audience, and our upcoming episodes are really in response to many of these comments and the amazing engagement that we have received from our national cohort of scholars and listeners and community partners. We have upcoming episodes on animals and food justice, on religion and sports, and our closing episode in May 2022 will return to religion and teaching. I want you always to remember that you can return to any of the episodes from this season or last season by going to our website and using those resources in your classrooms and in the larger community, because all of the episodes and the clips are available, and they are really useful conversation starters and also opportunities to think about the critical questions that we're asking in our field and across our communities. I want to thank the scholars who took time out of their schedules last month: Sarah Riccardi-Schwartz, David Robertson, Candice Rondeau, and Rob Saylor, for their great work and for their awesome engagement. Today, we are turning to religion and the Supreme Court. Religion and religious freedom are often key themes before the Supreme Court, and we have noticed these conversations not only in our local and national and international papers, but also in our classrooms and in courtrooms across this country. Both the current docket and the faith traditions of the sitting justices have ignited a series of questions around these issues of disestablishment, free exercise, and the ways in which race, class, and gender identity interact with each other and interact with these bedrock American principles. Today, we have an engaged and really esteemed panel, which will discuss the justices' understanding of religion, the ways religion is changing in America and changes American culture, and the impact of these combined variables on broader American life. I'm telling you all, put on your seatbelts and get ready for a conversation that we will not soon forget. So I want to just remind folks a few kind of housekeeping items. Please remember that throughout today's session, we are asking folks to submit questions through the Q&A feature on Zoom. And I know many of you have been using this for the last year and a half, so you know how to do that. Please put those in the Q&A feature. We will have the chat option available, but that will just be for kind of conversation between you all. But if you want to talk to the panelists, please use the Q&A feature. This will enable our hosts and panelists to engage these questions and to facilitate this important conversation. Now, let me introduce our host for today's conversation. First, I'd like to introduce Dr. Arthur Fonsley, who is a senior research fellow for the Center for the Study of Religion and American Culture and the research director for Religion and Urban Culture 2.0, both of those that are housed here at IUPUI in the School of Liberal Arts in Indianapolis. He is also a data evangelist for the Association for the Religion Data Archives. He served as the executive officer of the Society for the Scientific Study of Religion, SSSR, from 2007 to 2016. He's an expert in American religion and civil society, and his books have covered a wide variety of topics. The ones that I used in my classes last semester: The Bible in American Life, and one of his most well-known and highly respected books, Flea Market Jesus, which I love and would suggest to anyone who wants to read. And his articles have not only appeared in these scholarly tomes, but have also appeared on the cover of both Christian Century and Christianity Today. So it is with a great pleasure that I introduce one of our hosts, Dr. Arthur Fonsley. Our other host for this afternoon is Sally Berenger Gordon, who is the Arlen M. Adams Professor of Constitutional Law and Professor of History at the University of Pennsylvania Carey Law School. Dr. Gordon is well known for her work in American public life and the law of church and state, especially for the ways that religious liberty has been developed over the course of American national history. She's a frequent commenter in news media and looking at constitutional law of religion and debates about religious freedom. She has written on a number of topics and across a number of different venues. Her most current books project, which I'm really excited about, is Freedom's Holy Light, Disestablishment in America, 1776 to 1876. And her first book, which I read and actually had some experience with, Dr. Gordon, I don't know if you know this, but it was The Mormon Question, Polygamy and Constitutional Conflict in 19th Century America, which has won a number of awards as well as many of her other books have. And I am so excited that this esteemed national and internationally known scholar of law and constitutional law has decided to join us this afternoon. So without any further ado, I would like to hand over the reins of this discussion to Art and Sally, and to really begin and to listen and to learn from all of you. Thank you so much.
Thank you, Joseph. I would like to introduce our other two panelists. The first is Professor Fred Smith Jr., who is professor of law at Emory University School of Law. He's a scholar of the federal judiciary, constitutional law, and local government. In 2019, he was Emory Law's Outstanding Professor of the Year. Like many outstanding law professors, Professor Smith has also worked as a clerk for district judges, for circuit judges, and even for Justice Sonia Sotomayor. His work has appeared, as you might expect, Columbia Law Review, Harvard Law Review, Michigan Law Review. I don't know much about it, but I think those are good ones. New York University Law Review, Notre Dame Law Review, Stanford, Vanderbilt. You can just kind of put your own words in there and you will get those. He's been in the New York Times, the Washington Post, the Atlanta Journal-Constitution, National Public Radio. His JD's from Stanford and his BA is from Harvard. So again, we're happy to have you. Now, the other panelist is our colleague, Professor Beth Kate from the O'Neill School of Public and Environmental Affairs. And I should point out, many of you may not be aware that Indiana University has multiple campuses. Beth works on a branch campus of IUPUI down in Bloomington at the School of Public and Environmental Affairs. Her JD is from Harvard, so I mean, we're kind of covered over on Harvard people here. And she studied economics at George Washington University. She has co-authored the Supreme Court and Information Privacy in a book on bulk surveillance, contributed to the Global Encyclopedia of Public Administration, Policy, and Governance, and has written frequently on these topics. And occasionally I've even been a guest in her class, which is, of course, a tremendous honor for me. Now, I do want to say as we start here, first, welcome to all three of you. Also, Sally and I agreed at the beginning that, well, she didn't say this, but I'll say it. Since three of the people here know an enormous amount of about this topic, and I mostly know how to ask questions on this one, but I'll ask some questions. So I don't want anybody to think, wow, he's keeping her from asking questions. We sort of agreed we do it like that. So that's where we are. So I think everybody's aware the Supreme Court is in the news every day now, and religion has been high on the agenda. Some cases are explicitly about free exercise or disestablishment. Others involve statutes, such as healthcare mandates, government orders, COVID restrictions. Today, three genuine experts and me are going to talk about recent upcoming decisions and how brewing conflicts could affect the law and religion. So, first question coming up here. Many Supreme Court cases focus on the bedrock clauses from the First Amendment. I'd like each of you to talk a little about the important cases from the last couple of terms or the term currently underway that hinge on interpretations of disestablishment or free exercise. Could you talk about important issues raised in recent years and what you think we should be watching for going forward? And Sally, I think I'll start with you there if you'd be okay.
Thank you. That's wonderful. I didn't deserve that introduction, but I was very grateful to have it. So first, I'd like to say, really from the depth of long experience studying the constitutional law of religion, that it has never been this hot. There is a lot on the table, important questions among lawyers, judges, commentators. Everyone is deeply involved, and many are deeply worried, others quite hopeful. So there's been massive change already, and we expect more. So in the law of church and state, which is what lawyers refer to when they're talking about the two constitutional religion clauses, the beginning of the First Amendment, first, that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The law generated by those two clauses has changed drastically over the past maybe decade, even more quickly over the past 5 years or so. And one of the things I want to stress is that past cases are on the line as well. They're pretty much on the chopping block, including important ones that involve the Establishment Clause and the Free Exercise Clause. And it would be interesting to talk about those. You asked just for us to talk about a case or so in the past term or this term that we find important. And I'd like to talk about one that happened in my hometown, Philadelphia. Fulton against Philadelphia was decided in June of this year. And it featured a majority opinion by Chief Justice Roberts, which was extremely cautious and narrow. And decided that it would not take on one of those cases that are on the chopping block, one called Employment Division against Smith, which is about 30 years old and was written by Justice Scalia, but is under attack, continual attack by conservative justices right now. That case involved Catholic Social Services, which was contracted with the city of Philadelphia to provide foster care and adoption services, approving people to be foster parents, placing children, and so on. And Catholic Social Services said both that Catholics believe that marriage is only between a man and a woman, and they believe that certifying foster parents as potential foster care and adoptive couples means that the service itself would be endorsing any relationship that they are in. And although it has not come up in a given case, the city threatened them, saying, you must certify all people who are protected by our anti-discrimination laws in the city of Philadelphia, and that includes same-sex couples. And we should note same-sex couples have a constitutional right to marry. So there are really strong reasons behind this inclusion. The court held unanimously with various opinions, but everyone concurring in the result, that the city of Philadelphia could not hold Catholic Social Services to that contract. And concurring opinions argued in favor either of caution overruling the earlier case, the Smith case, or just saying, let's get it done right now. That's what 3 justices said. And so I think this case raises deep questions of equality. What counts as the civil rights that can match up to claims of religious belief? And also something that you mentioned, the importance of religious institutions today in claims involving religion, much more, not entirely, but much more important at this point than individual claims. So thank you. It's a great question to start off with.
No, thank you. I appreciate it. Beth, do you want to pick up there?
Sure, and thank you. It's a great pleasure to be here, especially with such esteemed participants. I'm really honored to be here. So I guess let me just say something that's sort of just a big picture framing set of ideas about where I see the court having gone. I completely agree with Sally about it's never been this hot and there's a lot at stake that is changing. I feel as though over that, if you will, 10-ish year period, what we're seeing is a narrowing of what the Supreme Court feels would violate the Establishment Clause, an expansion of what it feels would violate free exercise rights, and effectively the elimination of what it used to call the play in the joints between those two clauses. That is, we're at a stage now where effectively at the national level, that is the U.S. Constitution's Establishment Clause, what is considered a violation of the Establishment Clause will govern. Federalism is a bit dead in this regard, and what the Supreme Court has done is driving toward a situation in which, unless something pretty clearly violates the Establishment Clause, it will not be a basis for taking action that looks as though it is treating religious actors, individuals or institutions, differently than comparable secular actors. And so in that regard, I guess maybe I'll talk about well, I don't know. I could talk about Shurtleff or Carson. There are two cases in front of the Supreme Court. Yeah, I'll pick. I don't know. Let's see, which one should I pick? I'll talk about Carson versus Macon. It got heard yesterday at the Supreme Court, and this is a case that is it's the latest in a long line of cases actually involving school voucher type funding. So public funding, and the question of whether that public funding can find its way into a religious school. And so the case involves the state of Maine, which apparently only has about 20 people in it. No, that's probably more than that, but it's got so few people in it and so few students in its school administrative units, which is how they break this up for public school and public education purposes, that they don't have enough public schools to satisfy the needs of the students. And so what do they do when their state constitution also guarantees a right to public education, right? So what they have done is they have generated a program. They've had this program for many years where they provide funding that parents can use to send their kids to a private school if another public school in another administrative geographic unit is not easily available. And so for a number of years, when this program originated, you could take that money and you could send your child to a sectarian school, as long as the school was accredited. So any school that you send your child to with public funding will have to meet the ordinary accreditation requirements for quality of the secular education that the state demands. But then several years ago, Maine switched and they said, you know, from now on, you can only send your child to a school, a private school with this money, if it is secular, it's not religious. But the twist is that they say they look at the curriculum to determine whether religion is actually a part of the education. And the upshot of this, and certainly the way that the challengers, the parents who want to use this public funding to send their kids to religious schools that would meet the accreditation requirements, they're saying, hey, wait a minute, what you're basically saying is you cannot take the money if your child is going to a school where religion is actually taught alongside of the secular subjects. But if a school calls itself religious but doesn't really do anything religious, that's going to be okay. And this case really is the latest in a long line of cases where the Supreme Court has increasingly said religious actors get equal access to government resources, whether those are grant programs, whether it's funding like school vouchers and so on, if they meet the secular criteria. And if what you're doing is, so far what they have said is you cannot discriminate based on their religious status. Okay, that's one sort of line of statements out of the Supreme Court in these cases, and in the school, as opposed to they had left open the question, which I think will be resolved in this case, about whether it's different if the state is saying, well, we don't want the money to be put to religious use. And here they're telling us that they're going to teach religion. Okay, and they're really going to teach it. It infuses the whole curriculum. Okay, and so that status use distinction is something that I think the Supreme Court is going to hit and resolve, I suspect, fully in this case, and eliminate it and effectively say, look, this set of circumstances does not present any greater concern under the Establishment Clause. What it's really doing is discriminating against religious actors under the Free Exercise Clause, and therefore we're not going to permit it. I should note, and then I'll stop, the other thing about the line of cases that school funding in particular is generated is the notion that if you are giving the money to a parent, for example, and the parent is selecting where your child goes from an Establishment Clause framework, the Supreme Court is very comfortable with that because it says there's an intervening actor who is choosing religion over secular education and exposure to religion. It's not the government. And so those different threads, I think, have continued to weave together, and we find ourselves in Maine. We're the only people in Maine, but we find ourselves in Maine dealing with this issue. So we'll learn the outcome of that case, obviously, by June. But given the argument yesterday, I think Maine's restriction is not likely to survive.
Thank you for that, Beth. Fred, I will turn this to you, and I don't want you to feel at all obligated to respond, but to frame the question about what we should be looking for about disestablishment and free exercise the way you find most fitting.
Yeah, sure. Well, first, it's a pleasure to be here, and it's a pleasure to be on a panel with people who deeply study the law of religion, which I have to confess is not my primary area. But I do teach about federal courts, and I write about the rights of the dead, which brings me into at least some thinking about spiritual accommodations. But I'll say that, kind of in terms of this area of the law, a few words that come to mind are accommodation, another is discrimination, another is endorsement, and another is coercion, right? So in terms of kind of like really broad strokes, and then there's ways in which both when it comes to constitutional law and also when it comes to statutory law, that we can fit certain doctrines kind of loosely into some of those frameworks. So in terms of accommodation, these in the past, right, we primarily thought about that as a statutorily based set of interests. So there's a federal law, federal RFRA, which was signed into law by President Clinton, which essentially says that when the federal government is engaging in regulations, if they are engaging in a substantial burden on one's religious exercise, then the court is going to subject that to a very high level of scrutiny. And it was a way of kind of almost undoing the case that we heard about just a little bit earlier, Smith, at least with respect, and this is the part that is upheld, at least with respect to federal government action. Then there's also in the statutory space, there's RLUIPA, which is about state and local governments, and it's done under Congress's spending power. So it says that when a state or local government receives a certain amount of money from the federal government, then all the things that I just said, they can't burden religion, and if they do, then they have to have, then that's going to be subjected to a really heightened scrutiny. And so that's sort of a way of accommodating religion, even when there might not be actual discrimination. And again, primarily historically, that has been in the statutory space, but I think it's relevant here when thinking about the Constitution, because I think the discrimination space and the accommodation space are slowly melding. So in terms of the discrimination space, right, we primarily think of that in terms of the free exercise. And so what we're seeing in a lot of free exercise cases as of late is the language of discrimination. And it's both in the merits cases that we've heard about so far. It's also in a lot of cases from the shadow docket, that is cases where the Supreme Court has to act quickly when there's an emergency motion that's been filed. And we saw a lot of that in the COVID accommodation context, right? And there were these really great opportunities, and great, I just mean like rhetorically powerful and reverberating opportunities for the court to say things like, well, if this is true, if a person is able to go to a liquor store, then they should be able to go to a church, right? And sometimes not really engaging in a kind of a deep, close analysis of whether or not they were engaging in apples to apples comparison, but drawing on the language and the rhetoric of discrimination in ways that are very powerful and in ways that I think could resonate with people kind of beyond usual bedfellows. Then there's the historically the endorsement framework, which I almost hesitate to mention because it's so on the way out. But the case that we just heard about, the Carson case, is this remnant, right, of a moment in which the Supreme Court used to be deeply concerned about whether or not state and local governments were endorsing and entangling themselves into religion, acting with a religious purpose, et cetera. And so what we're seeing now is state laws that were designed to try to avoid these kinds of establishment clause problems. And they're running into claims that, well, but by doing that, you're discriminating, right? And the discrimination frame is winning the day. And then the last I'll say is just coercion. I do still think that there's likely some space, and we haven't seen some of these types of cases in a little while, but cases where if someone could really demonstrate not just that the government was entangled with religion, but that they were actually coercing someone to adopt a certain religion. I think there's still space there in the establishment clause realm, but that's just not what most of the cases that we see as of late look like. And then the last thing I'll say, because I put it out there as a possibility. So the discrimination space might start to be looking more and more like the accommodation space. So there's the language and rhetoric of discrimination. But when you read the reasoning, it's things like there's no exception here for religion. There's exceptions here for other things, but there's no exception here for religion. Now that's not the case in Carson, right? And Carson is explicitly I won't say single. I obviously listen to the oral argument, and it's all in my head. But I'll just it's intentionally. It's on the face of it, right? Religion is present, and making determinations on the basis of religion is kind of present in the law itself. But there's other instances like the COVID restrictions where that's not always as clear, right? And so the argument almost seems to be, if you're going to make any accommodation, one of them better be religious, and if it's not, right, then it's discrimination. And I think that's both kind of rhetorically, but also substantively in terms of and analytically. I think that space is really intriguing.
Thank you. My next question, actually, and I'm going to start with you, so I'll warn you now, Fred. My next question was going to be about discrimination, but also about equality before the law. I know from being in these before that a lot of our audience is interested in issues of racial justice, economic inequality, gender identity discrimination. And so I'm going to ask, are there cases people should be looking for in the recent past or in the current session, or that you see coming down the pike? Because people who do this for a living kind of also know what's in the pipeline. Sometimes when I talk to my American studies students, I tell them that sometimes in America, equality and individual liberty don't always work out. I mean, that sometimes you don't have the freedom to do things that are discriminatory, or sometimes equality of opportunity gives way to individual liberty. So I guess I'm asking, are there places we should be cases where we should be looking as we think about concerns for equality over against religious liberty?
Sure, right. And this is a good place also to think about the space where discrimination and accommodation intersect.
Yeah, that'd be great.
And so a case, I'm going to actually mention a case that on the face of it has nothing to do with religion or free exercise, at least in terms of what the doctrines directly in front of the court were. And that's Bostick versus Clayton County and the related set of cases where the Supreme Court, with a supermajority, held that under Title VII, which is the federal employment discrimination law, that employers can, when the fact that they can't discriminate on the basis of sex under the terms of the statute means that they can't discriminate on the basis of sexual orientation, and they can't discriminate on the basis of gender identity. And the court said, look, this is just a textual analysis, right? So if you're firing somebody because, John likes James instead of Jane, right? But for like all the work that's being done in that is sex, right? Or if you say, look, this person is performing gender in a way that is incompatible with how we think they should behave based on their biological sex and biology, right? Then that's discrimination on the basis of sex, right? And so, but also in that opinion, and there's great language, and it's definitely a victory. And full disclosure, I'm on the board of Lambda Legal, definitely a victory. And also, there's a moment where Justice Gorsuch says, well, very, very briefly, he says, now just to be aware, right, that that to the extent that that there's instances in which it would violate someone's religion to do this, right? That's, we'll save that question for another day. And that other day has not fully come, but it started to come. And so we've seen the court start to expand what it means to be a minister under the ministerial exception. And also, by the way, and ministerial exception is not language from Title VII. There's no language in Title VII that says ministerial exception. This is a judge-made exception that's intended to accommodate religious views and religious beliefs in a way that that really is kind of, at least among the justices, as a general matter, is a non-controversial position. But I do think that the expansion of what it means to be a minister and what it may mean to be practicing one's religious faith can be a space in which we could see the Title VII ruling kind of mean a little bit less over time. And although, I give the examples of sexual orientation and gender identity because that's the area that where this comes up the most, it's not there's no reason why it's inherently limited to that. I mean, and I'll end with one little example, which is a nearby small town, and I grew up in Athens, Georgia. I live in Atlanta. A small town in between those two places refused to hire someone as their city manager, and the reason that was given publicly for why was that he was in an interracial relationship, and that is not what God intended. And so and that actually happened while the Georgia State Legislature was debating a baby RFRA of sorts, and I don't know that was why Georgia didn't pass it, but it sure didn't help.
Oh, thank you very much. Sarah, Sally, do you want to pick up there?
Yes, I thank Fred, and that's a chilling story from Georgia.
Yeah, no kidding.
And I guess I would like to say that one of the things that seems evident at this point, so for example, on that shadow docket, Justice Alito said, I care about three things: discrimination against religion, racial inequality, and suppression of speech for the content of the speech, just those three. So one of the things that I think might be signaled there is that when a direct religious belief clashes with racial equality, the justices intend to stand by a almost 40-year-old opinion in Bob Jones University against United States, which resembles in some ways, Fred's story made me think of the case, in part because Bob Jones first refused to admit all Black students, and then would admit them, but only if they never engaged in interracial dating relationship. And that was the rule that was in place when Bob Jones was decided. And the case involved the tax-exempt status of the university, which was removed unanimously by the Supreme Court in 1983. That has remained a deeply controversial decision among some branches of American religious life. Many evangelicals say, well, we don't support racial discrimination, but that was the wrong decision. Sort of not defending Bob Jones, but attacking the court for its aggressive status action against racial discrimination. So one of the things to think is, well, maybe you really need your own constitutional amendment before you get protected as having a particular civil right in this era. And it is deeply concerning. It will be interesting to see how this plays out, and nail biting, I think, is the other thing I'd want to get across. We're all on edge.
Thank you. Beth, of course, to you.
Yeah, thank you. First of all, let me thank Sally, because I tell my graduate students, I teach Bob Jones at the beginning of my graduate law and public affairs class for a number of things. And at the end, I say, everything comes back to Bob Jones, and then we link it back. And so you have just validated that for me. So for any of my graduate students who are listening, it really does all come back to Bob Jones. So there you go. Just a couple things I'll add on, or echo, really. I do think that the expansion of the ministerial exception is something to watch here. That feels quite aggressive by the Supreme Court, and especially when statutorily we have a variety of accommodations already for religious institutions and actors in the non-discrimination laws. And so to add on to that, this what feels like increasingly broad gloss is something absolutely to watch. And one thing in that regard that's been quite interesting is to see how the lower courts are struggling with what they do with the expansion of that exception. So for example, it's one thing when you have an employee at a religious school, for example, who says that they've been fired in violation of a non-discrimination law. But what about when they're saying they're being harassed, sexually harassed, or harassed in some other way? And the lower courts have split on whether they're going to, if you're a minister, if your function is religious enough within the organization to consider you a minister, whether they just reject those claims out of hand, or whether they will go a little further to see whether there is any conceivable religious basis for the claimed behavior, because presumably at some point, a school will say, well, it's actually no part of our religion, perhaps, to engage in this kind of behavior, or, they'll have to defend it if they're saying it is. So I think the lower courts are struggling a bit with the expansion of that exception. And of course, the Supreme Court only hears a relative handful of cases. So for issues to bubble up to it ultimately to provide guidance, there's a lot going on in the lower courts for many years before we get another, I would never say the final word, but another chapter from the Supreme Court on this. And similarly, I think in that regard with what Sally and Fred were just talking about with respect to the Fulton case and this tug of war between when is, in the battle between religious liberty for an individual who doesn't want to supply a service to a gay couple, for example, who's getting married, and the non-discrimination values behind non-discrimination laws that apply to actors in the marketplace, who will win? I think the Supreme Court has really been trying to avoid that question or answering that question for a long time. I think Fulton is another example of that, in a way where instead what they have done is to go to what Fred was talking about, with giving almost a most favored nation status to religion, and saying if there's any differential treatment of religion vis-a-vis what looks like something we would say is comparable, then we think you're either not accommodating enough or you're discriminating. And that will get you the highest level of scrutiny from the Supreme Court. And they don't have to revisit the Smith case that Sally was talking about earlier, which generally says no one gets a constitutional level exemption from complying with generally applicable laws. But if you can show discrimination or differential treatment of religion, then suddenly you're in strict scrutiny world, and you have to have the highest level of justification for that. So I think these are incredibly interesting times, and this tug of war between equality and religion and religious values, where the court is either, they're trying to protect, I think what they probably see is a small minority of deeply held religious views that should be part of a broader composite landscape in America. This is how I read the conservative justices' statements in this regard, is that if we believe in diversity, then diversity is going to include some people whose religious views lead to conclusions that might be at odds with other concepts of equality and diversity that we're dealing with in the country. So I'll stop there.
No, thanks, Beth. Before I go to a third question, I want to encourage people who are watching this on Zoom to put questions in the question and answer box. Now, there's a teensy chance that you may feel intimidated about asking a question because you don't know anything about case law, but it's not stopping me. So I encourage you to go ahead and put those questions right in there, because I find I learn an enormous amount from hearing people who know what they're talking about talk about something. Maybe not so much, say, in microbiology, because I don't know what all the words mean. But in this case, I pretty much get what we're doing. And so I like that. Now, I am going to switch gears slightly here. And Beth, I'm going to tell you, I'm going to come to you first. And that is, there's a great deal of interest on who is in the members of the Supreme Court, the justices themselves. If I recall correctly, when Justice Kavanaugh's nomination was being considered, there was a lot of interest in America about that. And so on this particular issue, would you say that there were justices who seem in their decisions most committed to reinterpreting or restating constitutional laws surrounding religion in some way, and how might they do that? And I'm not asking you to make anybody the good person or the bad person. I'm just asking, are there justices who seem to think a fundamental shift is in order? And yes, that might happen over time and a series of decisions, but they mean to move in that direction.
I'd say yes. I think the ones most likely to do it most forcefully would be Justices Alito, Thomas, and Gorsuch. And then I think we're waiting to see what Kavanaugh and Barrett, how they shake out with a little bit more time. But those are the three who I think would overrule Smith directly, the case we were talking about before, basically to say if government takes action that burdens someone's religion, they have to have the highest level of justification to do that, and only do it as little as absolutely necessary to achieve that, that compelling need. Justice Thomas doesn't actually believe the Establishment Clause applies to the states. He thinks that that's a historically inaccurate read of the situation. And so, he has always kind of been a little bit different in that regard. But yes, and I think those three plus probably the other three who fall within what people call the conservative justices, so the Chief, Barrett, and Kavanaugh, lean more in the establishment side of things toward looking to history and tradition to feel comfortable with something that might be an expression of religion in the public square. Although, to be honest with you, Justice Breyer and Justice Kagan are sometimes in there too. Justice Sotomayor is almost the single outlier in some sense in a lot of these cases. So that's what I would say on this subject.
You and I have discussed RFRA laws several times, and just tell me if I have this right, and that is that there was in the law the idea of general applicability. If a law applied to everybody equally, then that was okay, and religious discrimination was not a big concern because it applied to everybody equally. If there's a shift here, that shift is in the direction of, no, if that burdens religion, the state has to have really compelling justification and interest to do it. Do I have that right?
Well, yes, in the sense that this would be a shift in interpreting the constitutional demands. Exactly, because the RFRA, as Fred was saying, is sort of a statutory way to impose that high level of justification on the government after the Supreme Court ruled in Smith that the free exercise clause won't get you that level of protection. So Congress and then some states said, we'll impose that burden on ourselves voluntarily as a matter of statute. But you're right, it's looking to shift back to doing that as a matter of constitutional law.
Thank you. Fred, if I could come back to you then, same general question. If I should be looking at any justices who you think there's a need for a fundamental change in some sort of constitutional interpretation with regard to religion.
Yeah, no, I mean, my math is the same as Beth's. I would only add though that, the opinion by the Justice Barrett and Justice Kavanaugh certainly also said things in Fulton that suggested that they are not that far behind. Like there's not, there's not a whole lot of daylight. If I were reading, that is to say, Justice Barrett expressed a great deal of skepticism about Smith. But she said though that she wants to sort of see like whether or not there may be something other than strict scrutiny that might need to apply in certain circumstances. But she seemed and Kavanaugh seemed just behind the other three. So I mean, I think they're close to the votes, and I don't think that overturning Smith, although it could have a dramatic impact down the line. Like I don't think that on the front page of the New York Times people would immediately understand what that necessarily means. But now the example that I give when I talk about Smith is right. Like if there's a law that says that people can't speed, and someone says, no, but it's really important for me to be at church on time, or something to that effect, and therefore, like I absolutely had to speed. That wouldn't be subjected to strict scrutiny. Everyone's affected the same way, right? As long as there's not actual discriminatory purpose, or as long as there's not kind of a singling out where you're treating religious folks differently than you're treating everyone else, then you don't use strict scrutiny. But what does it mean to treat religion the way you treat everything else? That's the category that keeps expanding beyond, I think, what anybody imagined it meant 30 years. God, has it been 30 years? Yes, 30 years ago when Smith was decided.
Thank you. So I will switch to you there with the same general question. Although it does seem to me that I'm hearing that there's some kind of big changes that are probably going to get set in the next term or two. But your opinion?
Sorry about that. And now I'm unmuted. I agree with the analysis that both Beth and Fred have very carefully put before us, and is exactly right. The contrast I'd like to draw, though, is with the Supreme Court that truly is obsessing about religion these days, right? I mean, this is really front and center. And I got a call from a British journalist this past summer saying, well, religion's no longer important. Why is the Supreme Court paying attention? And I said, what are you saying, Mr. Reporter? And he said, well, church attendance is down. And people don't care. The nuns, the people who have no religious affiliation, are growing very quickly. Membership is seeping away. And so why is the Supreme Court paying attention? And I said, well, it helps if you have a couple of constitutional clauses in your quiver, as it were. But also, I think that many people from outside the US and maybe some inside have confused religious affiliation with what is actually religious practice versus thinking more broadly about how people live their lives. So that one of the things that is so stunning in the jurisprudence we see today is the assumption that there's some static meaning to religious beliefs or affiliations, when in fact it's changing around us all the time. And so what I find most interesting, just from a pure law and religion perspective, is that people care deeply about these cases, but their relationship to the institutions that are bringing the cases, that are, if you look at Jewish and Catholic charities at this point, they're getting $2 out of every $3 from government at this point. Yeah. They're raising billions and billions annually through tax-exempt municipal bonds. I mean, they are really entangled financially. And so the way people are actually living their lives outside institutions forms something of a contrast to what's happening at the court, and sort of emphasizes some of that disconnect between the halls of the Supreme Court or federal courts generally, and the way we get through the day.
Thank you. Hey, I should say we have a couple of questions now, and I'm not going to call on somebody. So when I read these, if anyone wants to suggest they want to answer, and everybody doesn't have to. The first one is, how might we think about the Carson case in relation to exemptions to vaccine mandates? This sort of most favored nation status you've been discussing, how does it apply differently to individuals and institutions? And I will ask whoever answers that to tell us why the Carson case would matter, because the questioner knows, but I don't. So
yeah, well, it's interesting, right? I mean, so when I talked about COVID accommodations, I wasn't talking about vaccines because because my read, at least, and I'd be interested to hear from for the folks who are studying this more closely. These early COVID vaccine cases, even in instances like I believe in Maine, where there's not a religious exception built into the law, the court doesn't seem much interested in touching that. They don't want that to be their the kind of front and center policy that's where they're addressing these issues first. But that's I mean, to the point where, I mean, I'll say that, right? So in the court's emergency docket, typically anything that's at all controversial, it gets referred to the rest of the court. So one justice initially gets it, and they're allowed to rule on it by themselves, but that's not the practice. The practice is that if it's at all controversial, if you think that there's there's a chance that it'll come out a different way, then you give it to your colleagues, and that's not even happening in some of these cases. I mean, there is a dissent by the three people who Beth mentioned, Justice Alito, Justice Gorsuch, and Justice Thomas, and so they feel differently. But it is really important that there be religious exemptions in these vaccine mandates. But they don't seem to have a lot of allies on that score. But I'm curious. I mean, they may have different views.
Beth, you're both muted, so
well, I'll just jump in to say, I mean, Indiana University was actually one of those cases where, as Fred is mentioning, and we had a vaccine mandate with a religious exemption built in. We got sued by a number of students, and Amy Coney Barrett got that referred to her, and she didn't even refer it to the rest of the court and denied it after the Seventh Circuit had upheld the university's vaccine mandate. Just quickly on the Carson case, I think the difference there is in Carson, the issue is there a government benefit being provided that religious actors are being excluded from? as opposed to in the vaccine mandate context, we're saying, hey, if an organization, a public organization, requires people to be vaccinated, do religious actors get a special exemption from that? Otherwise, general sort of requirement. With the Supreme Court not taking the main case where you've got a medical exemption provided, but not a religious exemption, I too think that that's very interesting. It signals that the court really wants to stay away from this. The COVID cases where the court gradually sort of got to a point where they said, hey, you can't impose more masks and more distancing and things like that on churches and religious gatherings than you can casinos. That sort of signals that they really want to treat religion equally. Again, it's about equal treatment when you set that out. But if you have something that says across the board, we're going to require this, do you get out from under that on the basis of religion? And the only thing I'll say, I'll just throw this out there for whoever wants to think about it or comment, is when we talk about things like religious exemptions, given what Sally just mentioned about how broad the definition of religion can be and how people define that, how it morphs and so on, plus the reluctance of courts to say that one thing's really a religion and another isn't. When you get into the space of exemptions from the law based on religion, there's very little courts are going to look at to see whether you're really a religious actor or not, in which case the big picture question, I think, is why does the law continue to give, or should the law continue to give, religion or behavior that people deem or term religious special protection in the law? Because if we can't tell what's religious and what isn't, if we can't draw that line with any confidence, then where are we? So anyway, I will just toss that out there.
Thanks. Let me real quick, Sally, I'm going to turn to you, but there's another question I want to get out here before Joseph jumps in and stops us. And that is, someone said, I'm impressed by how often I hear from conservative American Catholics that they fear persecution. How often has the court stepped in to protect specifically Christians in this question, in the US from persecution? So I just put that, and Sally, I'll ask you, and I mean, if you don't have an answer to that question, that's fine, but someone did ask that.
Yeah, that's a really good question, because there has been in US history significant anti-Catholic prejudice and on occasion violence. So persecution happened, especially in the 19th century and on occasion in the early 20th. The major reconciliation between evangelical Protestants and Catholics that was memorialized in the document Evangelicals and Catholics Together, ECT, signed in 1994 by Chuck Colson, for example, an evangelical a religious leader whose prison fellowship ministries has almost I guess it's about $57 million annual budget, much of it through government contracts. So I want to just point out that many of these religious organizations have grown closer to one another, more supportive of one another, and more deeply tied to government funding over the past 20 years. It's been really remarkable. In terms of feeling persecution, there has been a shift, I would say, in the relationship of the Catholic Church explicitly to sort of taking a more developed legal strategic approach. So, for example, in the clergy sex abuse cases, we now have 31 separate Catholic dioceses having declared bankruptcy. That has proven a smart strategy for the church, gathering all liability in one court. Those are federal courts, bankruptcy courts, and really using the legal system to manage what otherwise could be an absolutely uncontrollable disaster. And that has worked. We see an increasing pace of declarations over the past 10 years among Catholic dioceses, as others have come out of the process pretty much intact. So that's been a smart one. The second thing they do is that they litigate aggressively. Fulton against Philadelphia is a classic example of that, where Catholic Social Services took the city to court and won. That was a victory. So one of the things to say about Catholic life today is that at the institutional level, the church has become a very sophisticated legal actor, has protected itself both through the bankruptcy process and through litigation. So they're doing well. They really are.
Thank you very much. And unbelievably, it's 4 o'clock. This hour goes quickly. It's been absolutely fantastic for me. And I just thank all 3 of the panelists, Fred and Sally and Beth, for taking part in this. The center owes you, and it was great. Now, for everyone else, thank you very much for joining us. Please click on the link provided in the chat to complete a very short survey. After this webinar, you'll also receive the link via email. We really do want those surveys, so please let us know your thoughts and opinions. On January 20th, tune back in for Religion and Animals and Food Justice. And within about a week, the recording of this webinar will be available on our YouTube page. That's our AAC Tube. Again, thanks so much to the panelists for this. It was genuinely great, so thank you.